Yes, Mamta ji, can we start now, please?
Yes, absolutely.
I think
Absolutely, we can
4
start.
बज गए हैं. अगर 2-4-5 मिनट वेट करना है तो we can move ahead.
I think let us start in next 2-3 minutes.
Okay.
So grateful for all of you to have joined.
I request everybody to remain muted so that we can hear each other in a better way. And second, the request is that if you can, if you open up your videos, then it will be quite interactive. And me and Mamta ji will love to see your good faces and interact with you also. Yes. Thank you, Rajinder Kumar ji. Thanks a lot. Admin, not able to understand your name, please. You can come forward. Right now we are just taking 3-4 months to start. Come forward and give your introduction. Rajinder Kumar ji, you give your introduction. Somebody from admin, you can start with you also. शमशेर सिंह जी नमस्ते. सत श्री अकाल, की हाल है? चलो जी,
अनुज
कुछ
स्टार्ट ही कर देते हैं फिर. आप बोलिए, आप स्टार्ट करिए.
Okay,
A very warm, yes, a very warm welcome to all your good selves. आप लोगों को मकर संक्रांति की बहुत बहुत शुभकामनाएं, और पूरे देश भर में जो खुशहाली आई हुई है उसकी भी आपको बहुत शुभकामनाएं. हम आईपा की तरफ से वी आर ग्रीटिंग ऑल ऑफ यू टू दिस सेमिनार. आई एम श्योर दिस विल बी क्वाइट फ्रूटफुल. वर्चुअल मीटिंग्स की अपनी एक गरिमा भी होती है और एक लिमिटेशंस भी होती है. तो इस गरिमा और लिमिटेशंस के बीच में हम इसको बैलेंस करने की पूरी कोशिश करेंगे. We are also very grateful to Kolkata, NCLT Kolkata Bar Association and the Association of Kerala, which is popularly known as KIPF Kerala, for having joined this program. And together we will try and tell you what are the good judgments. Good or bad is not the issue. What are the important judgments that has come in December 2025. Though December 2025 was a limited month because there were these holidays and vacations, but still we have quite a number of them to tell you. And PF notices how to handle. I think that's one of the very major issue for which a lot of people had called and told us to do this kind of a topic, and hence we actually chose to do so. So without much ado, we welcome all your good selves. There are seniors, there are peers, there are very important people. All of you are important. We see the presence of Shamsher ji, Rajendra ji, Madhusudan Sharma ji, my colleagues also, like Mr. Sharma, everyone. Thank you so much for being with us. Without much ado and wasting any of your precious time, let us straight get into the session. I request our president, Mr. Manoj Kumar Anand, to take this forward.
Thank you very much. First of all, I would like to start with that in northern India, it's very cold. That is quite visible from the dresses of the participants also. And most probably in western part of the country or in and around Mumbai and even in Calcutta also, it's there. Let me, formally start with our IPA meeting. Let me share my PPT with you. Let me give you a little bit brief about IPA. We have today webinar on landmark judgments, December 25. It will be taken by Mamta ji. P.F. notices, it is creating a hell of a problem for most of the practicing insolvency professionals, either as an IRP, RP, or as a liquidator. This is our YouTube channel. If any of you would like to look into our this presentation or earlier presentations, he can definitely look go to this YouTube channel. in today's webinar will also be recorded and immediately put in the YouTube channel. Now, since in today's meeting, I'll be discussing a lot of things which according to me is the right approach to for PF notices and other things there. And accordingly, I'm giving my disclaimer that it is only for educational purposes. As far as for running process, if you want to use these judgments, all these things, use your own discretion and without any legal liability of our side. iPad use. Okay. We held our last physical meeting, virtual meeting as on 25th August 2025. Uh, we do hold a meeting jointly also. And we held one meeting with KIPF as on 29th November 2025. Anybody from Kerala Insolvency Professional Association? Is there anybody from there? Because I would like him to come forward and say, tell about their organization also.
चलिए मनोज जी
Okay,
आगे बढ़ जाते हैं हाँ
okay. They'll be joining later on. Okay, and this is our 80th meeting. And during last 3-4 months, we were having a membership drive, which ended as on 31st December 2025, and now we have 264 members. Let's enhance it further. If people say, and a lot of people are calling me कि हम 31st December पे बाहर थे, ये थे, आप इसको 31st March तक extend कर दीजिए. If everybody says, we can go for it. In this particular drive, we were able to have 174 members. We have three new appointees. They'll be joining us very soon. Mr. Anil Goel, on the elevation of Mr. Nilesh Sharma as NCLT judicial member in Mumbai, presently posted Mumbai. Mr. Anil Goel ji replaced them. Our ex-NCLT member from Chandigarh, Mr. Dr. PSN Prasad has also joined as the legal advisor. We have Hemant Sharma ji also. Hemant was second to Nilesh in his entirety, and he has also joined us. IPA's contribution in the last 5 months. We are giving regular updates. Membership drive at only 100 rupees. Jabki, if you see for IP members and others, they are charging 1 lakh rupees for this thing there. We are a 7.5 year association, and we are contributing a lot. We contributed to the select committee also. Select committee, which was, which took opinion from the public related to IBC Amendment Bill 2025. Our IPA was represented by me at international event in Resolve also. Another thing is that there was a lot of hodgepodge, especially around 26, 25th, 26, 27, 28 December for non-renewal of AFA, because only with one agency, that is IIIPI of ICI. So we intervened, we interacted with the officers and gave the regular update to all the persons because who were concerned with it. And since last date to apply was 28th December for the IBBA panel, which starts from 1st of January to this thing there. Because of this, a lot of burden on them, this date was extended to 11th January 2026. And during this particular period, all who applied to the IIIPI till 20th December, their all memberships were cleared until unless some bigger issues were there. For example, some have not completed their CPRs. Then they put a section that you should first complete your CPR. Only then we shall renew your AFA. Since a lot of trouble was in December
What's up, Conan?
2026, then you have two options. Either you can move to ICSI or ICMI, where there was not much problem, and things are moving in a very proper way. And second thing is that if, since I am also chartered accountant, I would like you remain with the ICA only. In that case, try to apply early. 90 days in advance you can apply. The first week of October के अंदर apply कर सकते हैं. Let's learn this lesson from us. One of our member Anil Kumar ji, died all of a sudden, and We propose the movement. Actually, in fact, this IBC bill was supposed to be passed in winter session, but it did not, and now it is expected to be passed in the budget session. And we propose that our legal advisor, Mr. Prasad, will take care of the educating us on the bills, and it will be divided. It will be quite huge thing there. We shall have 3, 4, 5 sessions as per the requirement, and in this particular the bill, there will be we shall divide among our speakers. And if any one of you would like to be the speaker, IPA provides a platform to you. I welcome you to come over there and act as a speaker also. This session is going to start, say, in another 8, 9 days. Let's see when this IBC amendment will see the day of the light. This is there, this was there, select committee, and IPA was duly represented there. They have recognized our contribution there. The report, Parliament committee. We represented IPA in even in my digital capacity also. Hardly December first week may resolved event was there, and that was there. No, okay. Now I shall take this thing later on. Mamta ji, I welcome you. Please
Oh,
start your PPT.
thank you, thank you. Shobhit ji, if you can just place my PPT. Namaste, Prasad ji. Thank you for coming. Thank
Sir, आ
you.
गए?
Thank you so much.
Sir,
A great pleasure and pride. हाँ मनोज जी, आप अगर बोलना चाहें तो प्लीज।
sir, welcome. Can you on your
वेलकम।
video, please?
उनका वीडियो ऑन है। हाँ,
Sir, welcome. Unmute yourself and please, give your blessings to all the members present there. Please.
Yeah. A very good afternoon and good evening also, because it is at 4 now, and I'm happy that I am also a part of this organization. Let me see how best we can discuss and debate on current trends, legal issues whenever required, and let us work together for the growth of our association, as well as whenever any contribution from my side is required, I am ready. Thank you.
Thank you, sir. Thank you very much. Mamta ji, please continue.
yes, please. Thank you, sir. Most welcome. And you've always been the pride of NCLT, and thank you for your services there. And so grateful. Thank you. So, if I can just request, चौबी जी आपके पास है ना वो प्रेजेंटेशन? और
You want me to? Okay. You want me to start your presentation?
नहीं, उनके पास मैंने भेज रखा था।
Okay.
एक
Okay. I have with me. Let me. I can start your presentation. No problem.
नहीं, ऐसा कुछ नहीं है, एक बार देखती हूँ। I also have it. ठीक है,
The way you feel comfortable, I have started.
Okay, I have it. I'll just start. Okay.
Please.
Thank you. Straight away getting into the subject, because there are quite a few of them that we have chosen together to tell you what has happened in the entire month of December. We'll talk about NCLT, NCLT, some of the Supreme Court judgments, and also the High Court judgments. So what I request you is kindly give me your ears, maybe just half an hour of your attention span. And what I'll also say that whosoever is attending today's meeting, anyways, this will be there. We will also share it in the YouTube channel. We'll also share the presentation in the YouTube channel. But for now, I request your prime attention so that we can grab what is the issue that is being considered in the judgments. हमारे बस कानों में एक बार पड़ जाए तो आपको एक बार याद आ जाएगा, तो ओके, समथिंग लाइक दिस हैज हैपेंड, लेट मी गो अहेड एंड सी इट. In today's era and even in the past, we have seen that how judgments has really played a central role in adjudication. Definitely, we know that law is there and law is firmly there. At times when there is no confusion in the law, even then, the advocates, like I also work as an arguing counsel in NCLTs, I have seen how the judgments play a very vital role in actually cementing a matter. Okay, so let's therefore pay our attention to this. Now, what was the issue? This was in NCLAT. I'm not getting into the title of the judgments because that will take a lot of time. Let me straight away get into the issue. In this case, the bidder had failed to deposit 25% of the bid amount within the stipulated time. So what did the liquidator do? He cancelled the sale and forfeited the EMD. Now that was under challenge, and the appellate tribunal said that this forfeiture is well covered in law because it is absolutely statutory in nature, and it is not to be adjudicated by contract act. This is a special law, and therefore this EMD forfeiture flows from the statutory auction conditions and not a private contract. So therefore this kind of a forfeiture is considered to be good in law. Okay. What was the second case that I want to tell you is here, see, the CIRP of the corporate debtors failed, and the COC, where the appellant held almost complete voting control. What did they do? They resolved to liquidate and nominate Stress Credit as liquidator. The adjudicating authority disregarded the COC's nomination and appointed a different person as liquidator, prompting the appeal. So the appellate tribunal said that no, this prerogative is with the COC alone. If the COC is nominating somebody as being the liquidator, then adjudicating authority's role is very limited and they should not come in between this choice. So therefore, the NCLT's order was set aside. Home buyer's judgment that you see here, I was the one who argued this matter in Kolkata NCLT. I was representing 253 home buyers, and this has become a reported judgment. So in this home buyers, what had happened is, if I can briefly tell you, that the RP, the document that it had drawn, the EOI document and the detailed RFRP, one of the, in real estate, you can actually discover, and phase wise you can distribute it project wise. So in one of the project it said that only home buyers association are eligible to put in a EOI. So we fought and said that why only home buyers? It should also be open to the outside world, because it is not incumbent on the home buyers to give a resolution plan to resolve their own matter, because home buyers are not so, they are not so wealthy enough, if I can say so. They do not have the wherewithal to handle and make a resolution plan and then take it to conclusion. So this was then said that yes, it is correct. The NCLT mentioned that, see, it ruled. Look at the look at the decision of the tribunal. It ruled that eligibility criteria must encourage wider and genuine participation and cannot compel home buyers to assume developer-like obligations. This was Incab Industries. It's a very popular case which is going on in the NCLT for many years now. So here it said that, this is very important. So here it said that when somebody was admitting a claim, there was violation of FERA and FEMA, okay, and some related party transaction. So should that violation come in between claim admission? So the decision was that it cannot come in between the claim admission. The violation are separately to be dealt with, but that cannot come in between admission of a claim. Then, see, this is like, there was again in Incab Industries, it went into liquidation with an e-auction in which the applicant participated. But liquidation was later set aside and CIRP was rebooted. Okay. In the rebooted CIRP, Vedanta's resolution plan was approved by the COC and placed before NCLT. after which the applicant who had not participated in the rebooted CRP sought permission to submit a fresh resolution plan. So they said that it cannot be done because third-party plans, etc., cannot be coming into the picture at such a fag end of the process. This is quite interesting. State Bank of India initiated individual insolvency resolution process under Section 95 against two personal guarantors, and RPs were appointed who conducted the process and placed revised repayment plans before the creditors. The repayment plans offering less than 1.73% recovery were unanimously rejected by creditors, leading the RP to approach the NCLT under Section 114, so bankruptcy. So whether the RP's application satisfied Section 112 IBC and whether the tribunal should interfere with or remit the creditor rejected repayment plan under Section 114. So NCLT held that it cannot remit because the COC's decision will be final. Look at the last three lines. The tribunal declined to remit the plan for reconsideration, rejected it under Section 114, lifted the moratorium, discharged the RP, and granted liberty to initiate bankruptcy proceedings. So this was, see, this is very important. Whether appointment of a common RP issue, I'm reading the issue, whether appointment of a common RP for a parent company and its subsidiary amounts to a conflict of interest, warranting removal of the RP. The decision said that no, it is not a conflict of interest and it can definitely go ahead and do it. Fabtech Sugar, in this actually what happened, that the grid connectivity was cancelled during the CIRP for failure of complete final formalities. So therefore, this was challenged by the RP's office. So it was said that no, this can be done because during the CIRP, all such obligations will have to be met with. See this, what is the issue? Whether the existence of a financial debt and default was established so as to mandate admission of a Section 7 application despite objections based on MSME status, RBI guidelines, and evidentiary technicalities. So here the judgment said that even if the company is a MSME company, etc., nothing can come in between admission process, because if there is a debt and a default, it is mandatory that such a company will have to be then admitted into the CIRP. So there are many judgments, which talks about MSME status, etc. So this made it very clear that it cannot come in between. Now here, I'm not reading so much. I'll tell you what the issue is, that if in any SL, there is a disputed written in front of Section 7 or Section 9, which means financial debt or an operational debt. So the judgments are like that if there is a dispute entry there in any SL, then it will be considered as a disputed one. Then Section 9 cannot be admitted, is what they are saying. There are many 2, 3, 4 judgments that has come in December where it has categorically been said that if in any SL there is some dispute entry given, then it will be considered that it should not be taken up for adjudication because NCLT is of summary proceedings, and if there's a dispute tag which has been given in any SL, then it should be treated as disputed. This is quite a dangerous thing, but this is what it is at this point in time. Okay, so here in this is very, very cemented now that if SAP is successful bidder, okay, if you see SAP in the third line, that is successful auction purchaser. So if in the facts, let us go to the issue, whether the successful auction purchaser is liable to pay 12% interest on delayed payment of the balance sale consideration despite extension of time and prior statutory attachment. The judgment is very clear. It says that yes, it has to pay interest even if there is a prior statutory attachment or extension of time. Why? Because it went ahead and the appellate tribunal said that all these are on as is various basis. So nobody can come and the second fag end and say that no, somebody has attached, etc., etc., etc. It says that interest will have to be given. Now here in this matter, it's said that you may kindly give me your years in this. It's a very thin line of difference. If a corporate guarantee, okay, see, if in corporate guarantee, if a claim is being filed, then does that claim only is allowed to be filed when the corporate guarantee is invoked? That is the question here. I repeat, if there's a corporate guarantee and somebody is filing a claim vis-a-vis a corporate guarantee, is it compulsory that before filing the claim, the corporate guarantee needs to be invoked? Yes or no? The answer is that even if the corporate guarantee is not invoked, even then the claim can be filed and based on merits, the claim can be taken. Okay, they just read the decision because they took up the definition of the claim. So it was clarified. Just go to the end of the decision. It was clarified that a claim is a right to payment, whether matured or not, and does not require default or invocation. The RP and NCLT committed patent illegality in rejecting the claim on this ground. The impugned order was set aside, and the RP was directed to admit the bank's claim, reconstitute the COC, and reconsider the resolution plan. So I am talking about claim, not a CIRP admission. Okay, so there is a difference. I think when in CIRP admission, I'm just handling a matter where I have my opinion is that if you are if you're initiating CIRP basis a corporate guarantee, then definitely before initiation, corporate guarantee has to be invoked. Only then you get a leeway or field to actually invoke to file a
Claim.
CIRP. To file a CIRP, but in claim that need not be invoked.
Okay, Mamta ji, इसमें I just faced one very typical problem in this the thing there. What happened that State Bank of India filed a claim against my one of the CRP proceedings. At the same time, the amount that was granted by some other corporates also, and they revoked the guarantee there also. And when they revoked the guarantee there also, now for the same amount, they have a claim against me. And the other corporate the debtor who has given the guarantee, whose guarantee was revoked, they have he has also filed claim to me. Now basically for a particular amount, I have two claims. One by the State Bank of India, another by with whom SBI invoked the guarantee. Now, what will be your opinion in that case? Whose claim should be accepted?
I think the second one.
You would say, it is going to make a big difference in the
Yeah, because
whole COC.
that's yeah, I understand because that's the latest and present in time. So
You mean to say once SBI filed their claim, revoked their guarantee, in that case they lose the right of filing claim with me.
because you're saying the right of subrogation has already taken place, no?
It's not a question of subrogation. It's simply
Because
right
it's the
now.
second leg. It's the second leg.
Yes.
The second leg that comes into picture. So when that comes into picture, I think that is the one that has to be taken then.
But in my opinion, I may be, a bit different in that way. I just also delve a little bit into claim definition and all this thing there. Until unless with whom State Bank has revoked the claim, they make the payment to the State Bank. They can't say they can't put their foot in the shoes of State Bank.
Yeah,
In
no,
my
no,
opinion.
that we'll have to check the papers, of course. It
Okay.
all depends on that.
Okay.
But generally, that is how it
Okay.
needs to be.
We'll look into it after the
Sure,
meeting.
absolutely. Thank you. So here it said that the decision of the appellate tribunal, the NCLAT held that disqualification under section 21(2) applies only to a related party in presentee and not to the debt itself. Since Arcer and Rare ARC were independent entities with no relationship to the corporate debtor, they were not disqualified from COC participation. The assignment was bona fide and not intended to circumvent the law. The Supreme Court in Phoenix ARC held that the disqualification under Section 21(2) applies only to a related party in presentee, not to the debt itself, and this judgment was relied upon. Okay, so accordingly, Rare ARC was granted COC membership. I think this is one kind of a case which we actually encounter in every CIRP. that somewhere or the other assignment starts taking place, and we are always confronted with such situations. So sometimes the judgments really come handy. I'll just skip this because this is actually here it actually says this is the case that I had fought in the NCLT. It says that appellate tribunal. So in this case, what happened was that a Section 230 scheme was proposed by the promoter of the company. Okay. Now, when the Section 230 scheme was proposed, that time the law of Section 29A was not so much there. Okay, 29A was only there for the purposes of IBC provisions. Then later on, if you recollect, a Supreme Court judgment had come where the Supreme Court said that 29A will be similarly applicable to Section 230 scheme also. Section 230 scheme, which is proposed under the Companies Act, will also have the same acts of Section 29A that is there in IBC. Otherwise, if you recollect, in the initial days, it was allowed. A Section 230, even the promoters could have given. And so a lot of people were using it. But in Gujarat NRE case in the Supreme Court, it was held, Gujarat NRE promoter versus JSW, it was held that Section 230 under the Companies Act will also have the same connotation, and Section 29A will have to be seen. So what happened was that during the Section 230 scheme, there was a lot of expenditure that took place, and even the liquidator was operating. So liquidator then asked the proponent of the scheme to pay the expenses. So in that expenses definition, the liquidator's fees was also included. So the judgment now says that you can ask for the expenses per se. The liquidator's fees should not be included as a part of expenses. When you ask, because the scheme failed. So the law says if the scheme failed, the proponent of the scheme has to pay the expenses. So when this was the application, the decision was, now you read, the appellate tribunal concluded that the liquidator, decision of the tribunal, look at the last 5 lines, the appellate tribunal concluded that the liquidator cannot impose his remuneration upon a person proposing a scheme under Section 230, read with Regulation 2B. Therefore, the liquidator's demand does not fall within so and so, and the amount claimed cannot be characterized as cost. Okay. Now, this is a judgment. Here it says that, now this is very important for all the RPs at least. What the judgment is saying, please give me a little attention. It says that sometimes RPs and liquidators are precluded to act. So there's no books, there are no records. How can they hold AGM? How can they make financial statements or file them, etc. So here it is saying that, and it's very important, they say that RP should seek exemption from the competent authority where compliance is becoming impossible. So which means, say for example, if it's a company and you're not able to hold the AGM, then you should seek for an extension of AGM. Or that is how it says actually. So let me just read it. The NCLT held that non-cooperation by the suspended management made statutory compliance practically impossible for the RP. However, the RP remains duty-bound to manage the CD as a going concern and must seek exemption from the competent authority where compliance is impossible. This is the line that I wanted you to listen kindly. The tribunal directed the RP to apply for exemption from holding the AGM and filing financial statements and to take steps to reconstruct the financial records. Okay. Now, this is Supreme Court judgment. It's important. What happened was here, there was some private sale at.
Yeah. Madan sir want to say something. Please, sir.
Hi, Madanji, how are you? Such a pleasure. I was just thinking about you, that how come you are not with us today?
I'm always with you.
Thank you. No. I mean, I was
please.
thinking about you. Thank you for coming.
Yes, please,
Can
please.
you come to the previous slide?
Yes, please. I've come.
Do you support this order?
Yes, I do support.
Oh my God. Then you'll put our life in hell.
No, but because I have been doing it, Madanji, from day one.
I just come to this. It says RP remains duty bound to manage the CD as a going concern. It's fine, no doubt about this. And must seek exemption from competent authority where compliance is impossible. Now, in majority of these cases, I find compliance is impossible.
Yes,
Means
right.
the RP is supposed to go to ROC as well if it is listed company to the stock exchange and then apply for exemption
Yes.
and then wait for the exemption.
Madanji, I'll just correct you here because I've been doing it.
Because my view is, let me go. My view is that RP should endeavor.
Endeavor.
RP should endeavor, but not to do this compliance, go to the authorities and apply for exemption. If it is possible, he will hold the meeting. Not possible, he will not hold the meeting. Why should he go and seek the exemption? If it is not possible to hold the meeting, he will simply write to them that I endeavor to convene the meeting, but it's practically impossible to convene it. Where is the question of exemption? It's
Madanji,
why I'm
Madanji,
saying is
hold on. Madanji, let me just, sorry, I'll just come between. You are right. When you use the word endeavor is a right word. See, whenever we are reading judgments of NCLT judgments, they're sometimes also at the surface. They do not deep dive into the practical difficulties that a RP faces. What it is, let us just take the assets out of the judgment. You rightly said that you should say, for example, apply to ROC for extension of AGM. You should write to SEBI that how the unaudited financial results limited review is not becoming possible, etc., etc. So that is what we have to take a leaf out of it as far as the spirit is concerned. So allow me to just complete it, then we can just take it for discussions.
no, but the order says directed him to apply for exemption from voting. I mean, this is so much. I'm
But
not. If,
judges,
if you ask me personally, I do not support this order.
no,
I do
actually,
not support it at all.
Madanji, that's what I'm saying. We'll have to take the spirit out of the judgments because honorable judges do not get into exactly day-to-day things that we do. We have to take the spirit out of all the
But the
judgments.
problem is that if this order is not challenged, it becomes law of the land.
Not
That's
all
the
of them.
problem.
That's okay. I mean, see, at this point in time, this has not been challenged. And RP can never challenge. RPs do not have that much.
If it is not challenged, then it will be applied in all the cases, and it will be incumbent on the RP to apply for exemption.
Okay. So we'll just look at it. Everything has not become the law of the land. We also
It
know
becomes
the number of them.
that's what the judicial precedence is. That
It
if the
just
order is
has.
not challenged, then it becomes law of the land.
Adanji, I have seen how even now I'm deeply into it. So some of them have persuasive value, but it doesn't become the law of the land. Law of the land is always something which is written in black and white, and code in itself is quite black and white. So just allow me to just complete it, and then we can just take it up for discussion. So this is a Supreme Court judgment where it says, thank you very much, Madanji, for your understanding. So this is a Supreme Court judgment which says that the Supreme Court held that, as I was mentioning, that there was a private sale. So in this private sale, for the timeline of the payment, it continuously started defaulting despite extensions granted by NCLT. And that resulted in forfeiture of the amounts paid. So they again said that yes, this is very much allowed. And Section 74 of the Contract Act was being pleaded by Karshni Alois. So they said that that was inapplicable as the forfeiture arose from a judicial order, not a contract. So I'm by 2, 3 judgments of such kind, I'm trying to bring out the difference between judicial orders and a contract law. Because in such things, always the contract law is being actually talked about. So the appellant's lack of bona fide. So I tell you this lack of bona fide is very important. And abuse of process, this entitled it to relief and the appeals were dismissed. So here, this is something which I just wanted you to see it once, not that I want to delve upon it much. But here, what happened was the ex-director appealed against the Section 9 application, claiming full payment through cash and alleging pre-existing disputes based on police complaints and civil criminal proceedings. So I'm just trying to tell you that NCLAT held. So sometimes, any case that comes to us and we see a pre-existing dispute, we kind of pull our hands away from it. But I want to tell you that that's not the case. In sometimes Section 9 application, the judges always delve into and find out whether there is a bona fide dispute or it is, they want to segregate the shaft from the grain. That much is always done by the NCLT. So here also the same thing was done. And if you read the last 2 lines, the tribunal found no real or bona fide dispute and upheld the NCLT's admission of Section 9 application. So here, this is too much written, but I'll just tell you in short that if in Sarfesi always remember that sales, unless we give the sales certificate, the sale is not considered as complete. Let us have that in our mind in a very sure manner, that unless a sale certificate is given, the sale of the asset is not considered to be complete, okay, and final. Let us say complete, not considered to be complete. Now, in this case, what happened was a section 95 or 94 application was actually initiated, and in that, interim moratorium stepped in. It's a personal guarantee matter. Interim moratorium stepped in. So because of interim moratorium, obviously the moratorium provisions came into picture, and then the sale actually got stopped. So was it okay or not? The Bombay High Court said, yes, it is fine, because before the moratorium had settled, the sale certificate was not issued by the bank. Now that the moratorium has stepped in, this sale cannot now go to completion. Okay, that is how it is. Now let's see last line. Please see the last line. Extinguishment, since the interim moratorium under Section 96 commenced before completion of payment and issuance of the sale certificate, the sale was incomplete. Accordingly, the auction purchaser acquired no ownership or right to possession, and the writ petition was dismissed, leaving refund issues open. Okay, now this is that here it says that a person should a person be entitled to interest as a right, or should it feature in the documentation or in any agreement or bills, etc., that interest will be imposed? Only then should it be taken, or can an interest be asked as a matter of right? So here they say that no, interest cannot be sought for as a matter of right. This is, I think, about a claim here. So let's read the last three lines. Wherein it was held that is obliged to verify each claim. Okay, admission is strictly limited to substantiated amounts supported by record and verified evidence. The principle of equality among creditors does not override statutory requirements for proof. The RP was justified in admitting only the principal amount reflected in the books of account. Accordingly, the application seeking admission of interest, etc., was rejected. Because here there was no, see, go to the fourth line from the top.
Hello.
The RP admitted only the principal amounts due to lack of contractual or documentary proof of interest. Okay, so there was no contractual. This is NCLAT. The NCLAT held that if there, see, this is what I was telling you. Just go to the decision. The NCLAT held that Section 9 mandates rejection of a Section 9 application if there is a record of dispute in the IU. Okay. The tribunal ruled that insolvency proceedings cannot be used to decide contractual disputes. Since the NESL, this is something which we should know. Since the NESL record clearly showed the debt as disputed, the NCLT was correct in rejecting the application. Now, in this, it looks very big. So here it says they were, let's go to the facts once. Badrinath commoted and participated but was declared unsuccessful, alleging lack of fair opportunity and non-adoption of a Swiss challenge. So here, does it warrant judicial interference? The judge said, no, it doesn't warrant any judicial interference, because just read the last two lines, last three lines from the bottom, reiterating that the liquidator's commercial wisdom is not subject to judicial review. Relying on settled law, the tribunal reiterated that the commercial wisdom of the liquidator and SEC is not open to judicial review. Okay, now let's go to this. Here it said the NCLT upheld the, what is it actually? What happened was, in this matter, this company, Section 45(1)(e) of the RBI Act was actually rejected. So therefore, does it still come under the special law or not, as a financial service provider was being adjudicated upon? So the NCLAT upheld the NCLT order and said, once the board of a financial service provider is superseded by the RBI, okay, not this matter, that was another matter. Here it said, if you recollect in CIRP, the directors of the suspended board have the right to get all documents, etc., right? But you are aware that in RBI initiated process, what happens is directors are deemed to have vacated office. I'm sure you're aware by now. So the directors are deemed to have vacated the office. Therefore, the law said that therefore they have no right to participate in CIRP or seek copies of resolution plans. Okay, so the appeal was dismissed. I hope I've been able to make my point here. that the suspended director is CIRP of this works differently. Here, actually, they are deemed to have vacated office. So therefore, they have no right to participate or seek any copies. Okay. Now, this is again massive cash withdrawals and unexplained reimbursements, etc., took place. So, should it be considered as being under the lens of Section 66 of the Act or not? So, therefore, they said that yes, it does. It should come under Section 66 of the Companies Act. Why I bought this judgment here is because sometimes, we get very wary when some cash or large scale cash withdrawals or etc. starts taking place. So we should actually bring it under the attention of the COC and then file a Section 6 application, 66 application. In Section 66 application, there have been umpteen number of judgments where they say that unless you have very verifiable facts which you can support by proper document, you should not file such an application, okay, before the NCLT, because it is just kind of, it is said that then probably the RP's office is just trying to vie away from its responsibility by just filing an application without any supportings. But I have seen how IBPI notices later on really raises a lot of questions and why did you not file, etc., etc. So sometimes if you have an SFIO investigation happening or if you have CBI coming in and filing a report, etc., then I feel that basis the report also, you should go for a Section 66 application, even if you feel that you do not have such solid documents to actually back up a Section 66 application. But even then, as per my experience, I would humbly mention that please file a Section 66 application. Otherwise, the regulators, will actually come ahead and, you may face some questions based on that. Okay.
Okay.
Here, this is important. The operational creditor alleged excess payment to the corporate debtor for supply and filed a Section 9 application, which was admitted by NCLT, despite the corporate debtor disputing the liability and recording a dispute. So, is it okay or not? It said further held that this was a claim and not hit by moratorium under Section 10A, was entitled to initiate. Now, here, the NCLT set aside the NCLT's order. Okay, let's go to the next one. Held that what was this? Invent Assets filed a Section 7 IBC application against so-and-so for default of about 100 crore arising from loans assigned by Indian Bank in 2016. So despite an accepted OTS and partial payments, can such an application be admitted? So it said that yes, it can be admitted. Okay. SEBI, here what happened, this is very common and you may like to hear. SEBI actually imposed a monetary penalty. And when did it impose? When the company went into liquidation, in the process of liquidation. Okay. So was this to be taken in as a claim? So here it said that it cannot be taken in as a claim. Let me just read it because it's the appellate tribunal and it happens quite often, sometimes by SEBI and some other regulators. So it said, the NCLT upheld the rejection of SEBI's claim. Only claims existing as on the liquidation commencement date can be admitted. Since SEBI's penalty order was passed after liquidation had commenced, the claim did not exist on the relevant date and was therefore inadmissible. Okay. Now here was that whether issue ko padhiye please, whether a belated claim of a home buyer reflected in the records and information memorandum of the corporate debtor can be ignored. Okay, can be ignored after approval of the resolution plan by the COC, but before its approval by the adjudicating authority. So please understand, it's a claim, but a belated claim. ऐसा नहीं कि उन्होंने claim file नहीं किया था home buyer ने. It's a belated claim. So NCLAT held that it cannot be ignored. The NCLAT held that while a belated claim cannot be formally admitted after COC approval, such claims do not stand extinguished until the resolution plan is approved by the AA. Since the appellant's allotment and payments were reflected in the corporate debtor's records and IM, non-consideration would result in inequitable resolution. And it actually had sent the plan back. So I think this is something which we will have to take care of. This is very, very important. And it's a decision of the appellate tribunal. So it has more binding kind of a nature. So I'm not getting into this. So here also it is saying that if you decision of the tribunal, if you read that NCLT held that financial debt and default were clearly established through loan documents and repeated acknowledgements. So this has to be then taken into consideration. Here what happened was shareholders actually, please read the decision of the appellate tribunal, go absolutely in the last para. The inquest held that although shareholders generally lack locus to challenge CIRP admission, a limited challenge alleging fraudulent initiation under Section 65 IBC is maintainable. And I'm seeing it in NCLTs now left and right, that fraudulent applications are actually taken up by the NCLT very, very strictly. I mean, if they find that it's fraudulent, even if the CIRP has started and has reached a stage where you feel will not get reverted, it's actually being dismissed. So one has to be very, very careful with this, that it can be taken up even at the most fag end of the process. Okay, so this was also about valid invocation. This is very, very important. This you may please read it. This is very, very pertinent. It said, held that liability of a personal guarantor arises strictly as per the terms of the deed of guarantee and only upon valid invocation. So whenever a section 90, even 95, etc. is being filed, the first thing you should see for your client is whether the deed of guarantee has been invoked or not. It went ahead and said that the surfaces notice under section 13/2 or a Form B demand notice under Rule 7 does not constitute invocation of guarantee. This is very, very vital. Okay, so this is the first thing that we nowadays see. Then this is also again genuine, genuinity. I'm not getting so much into it. Since we will leave this presentation also, you may kindly read it at your end. This is also, I'm just skipping once. See here, this is quite, we will keep getting such cases now. What it said was, some company filed a Section 7 application against Jumbo Finvest for loan default, which was rejected by NCLT on the ground that Jumbo Finvest is a financial service provider. But now what happens? See, the key issue was whether CIRP under Section 7 could be initiated against an entity registered as an FSP. So you know that financial service provider cannot go under the normal CIRP provisions, despite RBI restrictions on its operations. Now what happened? NCLAT upheld the NCLT's order. Why? Holding that Jumbo Finvest continued to be a financial service provider until cancellation of its RBI registration. Mere regulatory restrictions on lending did not strip off its character. CIRP against an FSP can only be initiated in the manner prescribed under Section 227. So just because, this company had some restrictions of lending, so it doesn't change the color. Until and unless the registration is scrapped, etc., it will always remain an FSP, is what they said. Okay. So here, this is again.
Mamta ji, bit fast, please.
Yes, I'm just finishing in next 2-3 minutes. Okay. And see, this is important. It said that in this case, in liquidation, 12A was invoked. So the judgment was that in liquidation, 12A cannot be invoked. 12A is under chapter CIRP, chapter 2. It cannot be invoked under liquidation process. This is an apex court judgment that this is about arbitration. This is quite a settled law that arbitration and this thing has to be treated differently. And this is under the CIRP that arbitration was happening. So arbitration will have its own course. Okay. Now, this is something which has happened. Del Credere agreements, a Del Credere agent can actually now be treated as an operational creditor, which was hitherto not possible. So this is, I've written an article also in Economic Times about this, that a Del Credere agent can now be treated as an operational creditor, which was hitherto not allowed. There were some judgments.
Sir, abhi connect karta hu aapko.
Okay. So this was malicious and this was okay, I'll stop here and these are all, we will send it to you. This is all about SARFAC. With this I will close. So what it said that whenever a section 45, 49, 54, 66 application is made by an RP or sometimes by the liquidator, they said you should have proper pleadings invoking such sections. You just can't say that this is coming under PUFE ambit. No, this is not allowed. The judgment categorically mentioned that the specific pleadings could be there for those number of sections, quoting the sections that what is it falling under. So with this, I'll close my presentation. There are not umpteen of them now left. So I think we were almost about to finish. Thank you, Manoj, and thank you everyone for your kind patience. I'll just close this.
Thank you very much. Thanks a lot. Yeah, Anilji has just joined us. Anilji, can you come forward?
Namaste,
Give your introduction. इनकी इंट्रोडक्शन मैं ई की 2 लाइनें में दूंगा. बाई चांस आई केम टू नो yesterday only कि ये इनके फादर इन लॉ ने 80 साल की उम्र में आईबीसी का एग्जाम क्लियर करा था. 80 इयर्स की एज में आईबीसी का एग्जाम क्लियर करा था. तो इट मीन्स कि अगर ये इंडिया में नंबर 1 है तो इसमें इनके फैमिली की कंट्रीब्यूशन ज़्यादा है, इनकी भी है साथ में. विद दिस नोट आई रिक्वेस्ट अनिल जी टू से फ्यू वर्ड्स अबाउट हिमसेल्फ. इनको ही इज अ नोन पर्सनैलिटी ऑल ओवर इंडिया, बट स्टिल कम फॉरवर्ड, प्लीज कम फॉरवर्ड.
So thank you, Manoj, and I will share with you, Mamta ji. In fact, my father-in-law,
so much for coming.
Mr. Kamal Goyal, and he in fact passed this examination of insolvency at the age of 81. And Dr. M.S. Sahu in fact has been saying in various meetings, whenever somebody was telling that this exam is difficult, we are not able to pass it, and they were only referring to the name of Mr. Kamal Goyal, saying that in case he can pass it in first attempt, then you can also pass it. Just go and read and study. That's what he was using for many number of years. And the last case, like he expired 4 days back, and the last case that he handled was a liquidation case, which in fact I handed over about 2 months back. So he in fact handed over about 5 cases, and the last case that I handed over to another person is the 2 months back, because he was not able to sign because of the neurology problem. So see, like yesterday, in fact, when we were doing the prayer meeting, we decided that we will not be considered as family in grief. So we celebrated the life of Mr. Kamal Goyal. That's what Manoj ji, in fact, he was there personally present in that celebration of the life of Mr. Kamal Goyal. So that is what.
So sorry to hear, but
so that's like. So as Mamta ji, we all decided that the focus should be that there will be 2 associations across India. One is the Association of Insolvency Professionals, and the other will be the Association of IPEs. That is the focus that we are taking ahead. Prasad-like people, the learned people like Prasad ji, I can see him on the screen. So if they would be with us, so we would be very soon, we would have chapters across North, South, and Eastern India, and we would actually try that such people should lead us. And any kind of event you can plan and develop membership. We are not keeping any high amount for membership. That we want to make only one statement, Prasad sir, that every insolvency professional is our member. That is the only statement that we want to make, and then it will get value, sir. Please don't bother about the cost. There will be a lot of people who would be sponsoring. Mamta ji, we all will be using our relationship. Every member of ours would be using our relationship. And when we will say that we are the largest and only one association, I believe any kind of event. So the most important objective is the improving the image of insolvency professionals. Presently, we see that the respect is declining because everyone is saying that there is a lot of differentiation between the knowledge, infrastructure. So the NCLT members are also trying kind of a punching bag kind of a scenario. So we actually have to invite members whenever they join whenever they come to the bench, whenever they leave bench. So those kind of activities will actually, first of all, appreciating their efforts, and then also communicating to them that these are the difficulties even RPs are facing, liquidators are facing. Then they will come to the reality that we are also human beings, and what is expected from us at times is something which is superhuman being outcomes. So that is when we will actually convey to all NCLT members, IBBI senior authorities, then our kind of respect will increase. That is what is the focus. And in fact, we made one effort, and I believe more than 100 people joined. We will all collectively make another effort, and we will see that everyone joins. And I was telling Manojji that whenever Mamtaji visits Delhi, we can have a meeting, and we can also have a podcast.
Absolutely.
Only on one subject, how to take this association forward. Please give us at that podcast, and we all will try to circulate. All our members will be circulating, and see, like, we will also kind of ask various other our respected members, erstwhile members of NCLT, to join that podcast, so that it becomes a collective voice, and then it will be circulated to everyone to say that let us focus only on one association in India, and that is for insolvency professionals. Yes, please. मनोज जी, आप कुछ ऐड करना चाहेंगे? ममता जी, प्रसाद सर.
Thank you very much. Only thing I would like to add is that we've been able to have more than 250 members right now, and our membership drive ended on 31st December. But now, as you're saying, we can extend it to 31st March if everybody is feeling let more members be added there. So I propose to extend it to 31st March, so that I see a lot of calls. People are saying that because of 31st December they were busy and could not join all this in there. So if everybody is okay with me, then we can extend it to 31st March. Okay. Now people are waiting to Anilji and Mumtaji. We shall talk about this and then conclude it.
Yes.
Extension to 31st March.
Kindly
Now
take
move to
forward.
people be
Manoj ji, अब आप एक बार please take this forward.
Yeah. Okay. It's approved now. Anilji, what do you say?
No, I said nothing, because this is what was. In fact, I have also to go today. Is the event of Sumant Batra, so I've had to leave. So I'm also leaving the this group now. Thank you.
Good.
Thank you very much.
Fair enough. Okay. Now let me start my.
Merji, namaste. How are you, sir? Yeah, you are.
Sir, अपना जरा वो कर लीजिए. Please close down your yes, mute. Okay. I think my PPT is not being shared. Yeah. I'm just hold on. I'm just again opening up my PPT. Yeah. Let me move to. Okay, PF notices, how to handle. My presentation is based, basically is with the objective that instead of indulging much into law, understanding the nitty-gritty of the whole process of PF notices. Because me also, whatever processes I'm running, if anybody files any claim or not, but notices from the PF generally do come out to be there. As far as judiciary is concerned, no, dominatingly they are saying that in case of any demand, new demand is raised after assessment, all this thing there, then It is bad in law, but still some contrary judgments are there. But before we move forward, as a resolution professional or as a liquidator, let's look. What happened whenever we say to our advocate कि ये PF वाले जी इतनी डिमांड कर रहे हैं, they say, oh ये तो बायजूस की judgment, you have to pay, and you have to pay it before your liquidation cost also under section 36 subsection 4 subsection A subsection 3. And and at the same time, when I go a little bit deep into it, I feel ये पैसे तो अपने पास लेकर रख लेते हैं, किसी एम्प्लॉय को देते तो है नहीं, and in that case it gives me a lot of pain, as a as a process runner, it gives me a lot of pain, because because of this thing, that on the one hand, financial creditors or even the operational creditors who have invested their money in the business, they are not getting anything, and these PF people are earning, or maybe getting money because of particular provision in the law, and at the same time they are making money out of it. In any case, let's delve a little bit deep into it. Chandan? Okay, what happens? Trigger of PF authorities. अरे EGS की COC start हो गई है, लगा देना EGS की. Trigger of PF authorities action. PF authorities generally become active upon publication of Form A by RP, receipt of intimation, from NCLT, assessing data for admitted CRP cases from NCLT portal. Actually, what is happening is that when I have a talk with the PF authorities, especially in Delhi, they say कि हमारे पास periodically NCLT से डाटा आता रहता है, और जैसे ही जो कंपनी CRP में आती है, and we issued, they have a computer based data with them. Based on that, whatever is there, they start issuing notices to them. Immediate action post admission. They start issuing inspection notices. They were sleeping, if CRP, if the company was alive 8, 10, 9, even 15 years ago, but the moment it comes to the CRP, they will wake up. But till that time, they are sleeping, because they are aware of it, that nothing is going to be come out to them. Issue inspector notices and ask us to produce record within 2, 3, 4, or maximum 7 days. If you ask for the adjournment, then they start giving their plea against PF Act and all this thing also in there. What inspector does? He started inquiry and start proceeding under the PF section, under this particular act, section 7A, 7K1, 14B. And he files his report. He files his report, which has, I should not say has no basis, but I should say has arbitrary basis. Based on that particular report, concerned assistant commissioner or whatever authority under whose jurisdiction this is coming out to be there, he passes an order और आपके सामने एक चिट्ठा थमा देता है, and इस डिमांड का, और कहता है कि ये पैसे हमारे को पे कर दो. Okay, before we move further, let's understand some basic things in this particular section. What section 7E of PF Act says, because when we are running a process, wherever we get hit, till date we are mainly concerned with SEBI laws or income tax laws or GST laws for our compliances, but this PF is also taking a mammoth proportion. Let's understand what section 7A says. 7A says determination of money due. Purpose: to determine the amount allegedly due from the employer towards provident fund, pension and insurance contribution. Quasi judicial assessment. Understand, it's a quasi judicial assessment process. The employer IRP is required to participate and present submissions. On the other hand, when IBC was started, to see the basic purpose of section 14 moratorium, it was basically that an RP should run the process in such a way that he should be more concerned of bringing resolution for the company rather than wasting his time. That is why stoppage was given to all the cases. But in the case of PF, it's basically hell to you. In one of my case, where I'm an RP, I have more than 30 hearings. More than 30 hearings. And what is the purpose of that hearing? I'll let you know again. meaning thereby that their present, their notices, their all this thing, their it virtually kill our time rather than anything else. Outcome and order determined the ledger dues payable by the corporate debtor. Oh, sorry, your slide पहले आ गया था. 7Q. 7Q is they impose interest on delayed payment. What interest rate is simple interest rate or higher. They have a periodical that if default is of 6 months, then 12%. If default is of falls between the period of 1 year and 2 year, then it is 18%, and something like that. They have this thing there. Above that, they imposes the damages also. Section 14B empowers them of imposing a damages. This is basically to discourage PF default. And yeah, this is this damages rate changes from 5 to 25% depending upon the period of default. This is what we face, what I've just talked to you. PF authorities frequently require the IRP to attend hearings. Hearing often given with a short interval of 2 to 3 days, and continuous engagement and significantly burdens the CRP process. All this, I just talked to you. Let's move forward. What is Section 30? They say that they have a right prior to even liquidation process cost or even CRP process cost, because Baju has very clearly said, and a lot of other judgments are also there, whereby they say that this liquidation provision is also applicable during CRP, and they get shelter under Section 36, subsection 4, subsection A, subsection 3. Let's read it deeply what this section says. Okay, liquidation state. It says the following subsection 4, the following shall not be included in the liquidation state. Asset and shall not be used for recovery in the liquidation. Assets owned by the third party which are in possession of the corporate debtor, including so and so. Or we are here concerned with subsection 3 only. All some dues due to any workman employee from the provident fund and pension fund, meaning thereby that it says that in the case of liquidation state, which we file asset memorandum at the start of the liquidation, that any sum due to any workman or employee from the provident fund and pension fund, if any amount is due there, then it won't be part of that particular liquidation state. If we look deep into BLRC report, what BLRC report said, that many a times it happened in the case of such companies, that the employer do deduct salary from the PF from the employees. Along with that, they are supposed to deposit a contribution in the designated fund or something like that. They don't deposit, just to keep it away from the liquidation process, or they brought this provision that because this should not be form part of the liquidation state, and it should be paid to the particular fund with this thing there. But with the passage of time, which I'll be sharing with you just now, that a lot of judgments came out to be there, whereby they including everything therein, including all defaults therein, interest penalty as part of dues which are which they have a right to, PF authorities have a right to recover under section 36, subsection 4, subsection 8, subsection 3. अब इसके अंदर अगर if you look deep into it, in my opinion, this benefit should not go during CRP period. But my lords have held it should go. It has to go, especially when Honorable Supreme Court has heard in the case of Baiju. And they have also said that this thing is there. Interest plus penalties all should be there. There, why? I was a little bit delving deep into it. Why courts are holding this thing more in favor of the PF authority? They say that whenever they have to adjudicate between two case laws, they compare it not two cases, but between two two acts. One is Code and another is PF Act. They say that PF Act is a beneficiary act, and if there is any conflicting situation with the IBC, we should give preference to the PF Act, and whatever stated therein should take precedent of the IBC also. But it definitely runs against the IBC code and all this thing there. But my lord has held this thing. We have to abide by this thing. But now situation is changing when they realize that there is an unjust enrichment on the part of PF authorities. They have started abusing this particular section, and there is a just unjust enrichment on their part. In some of the cases, they filed Form B or F with me. In that case, in that case, I don't fight much, and I also don't have any problem. And I classify that under the waterfall mechanism under Section 53, subsection 1, subsection F. As a remaining debts and dues, or maybe as a government dues. But I classify them under this thing there. In that case, even if penalty is there, even if interest is there, I don't mind in classifying there. But my problem comes out to be there when they start asking us to pay under Section 36, subsection 4, subsection A, subsection 3. This is the file claim B and F form. Another problem I do face is that if you have a case which is geographically scattered, then they have a jurisdiction area wise. Then you start receiving notices from all the places. I just give you an example. I'm handling one case, Patelwood. In this case, I received notices from Gujarat. I received notices from Delhi. I received notices from Haryana also. In the case of AGS, we have in that case we are receiving notices from all over India. And it's cumbersome to reply and give their. If you don't give reply them properly, whether you have a record or not, then they'll pass an ex parte order. Okay. Now, in my particular cases, what I've seen is that how they calculate the demand. When we say to them that we don't have any record pertaining to this period, then whatever last contribution, say, even if it is 7-8 years ago, let's say last contribution was of 1 lakh rupees, then they will calculate it till the CRP period date, based on that 8 lakh into my, let's say 1 lakh rupees were per month, 1 lakh into my 12 into my, if case is 5-year-old, 60 lakh rupees they will generate a demand. Along with that, they will impose an interest of 12 to 24%, and along with that, they will make a penalty of 14B for damages. एंड आपके हाथ में वो कहते हैं जैसे हम इनकम टैक्स की प्रैक्टिस करते थे तो एक डिमांड नोटिस आ जाता था विच वाज एक्स पार्टी डिमांड नोटिस और notice without based on the whims and wishes of the concerned officer. And on the one hand, you don't have money to run your CRP process. They will issue you a demand notice, which may range from 50,000 to of any above amount. No, just to curtail that thing, that how we can get rid of their imposition period. So what we generally do is that we look deep into the audit reports, because audit reports, we have two types of audit reports generally with us. One is of statutory audit report because we are working for the companies, and another is of tax audit report. I just give a suggestion to you that in the case of Caro is applicable in most of the companies. The details of PF dues is given under clause 3, subsection 3, subclause 7. Here a lot of details are there, but you can look into your required details of EPF. And here the outstanding dues, if anything is there or something not is there over 6 months, a statutory detail is judicially required to look into it. You can curtail their period by having by having an information from the core report of the company, past company reports of the company, until unless a company has not audited their accounts or they have not filed their audit report. In that case, big handicap is there. But otherwise, you can look into it. Another, I found that we can have curtail their period by looking at the Form 3CD of the audit reports. Here, Class 20B, employer's contribution, Clause 21B, employer's contribution, and Clause 36, Section 43B, applicability, Clause 44, payroll reconciliation. All this can provide you the information of genuine PF dues. In our tax audit report, we prepare tax audit report in such a way that if any, let's understand it with an example. If any PF dues is there and it is not paid, it has to be shown as unpaid, because this is disallowed under Section 43B of the Income Tax Act and added to the computation. And we paid subsequently, then it is allowed also. Then we deduct from there, and from there we, at the end of the every financial year, we get a chart that how much actual dues are payable against PF. So this report can also help you to fortify your stand before the PF authorities. Yeah, this is a summary of, again, same relevant clauses. Delayed deposit of EPF, due date versus actual payment, amount disallowed under Section 36(1)(5)(a), employee contribution, ledger of 43B. So these can really help you out in curtailing their huge unnecessary demands. So please have a look on these reports so that when we are running a process, let's run it for the benefit of all the stakeholders rather than giving unjust enrichment to the PF authorities. These are, comparative clauses. You can have a look on it. I'll be sharing my PPT with you right now also. Even I will share with you on my YouTube channel also. Okay, now let's let a little bit deep into inspector's report. The inspector's report is often submitted without granting proper scrutiny of the hearing, after hearing, but without adequate time or records being made available to us. And then as an RP, what should we do? What, the question rises, as an RP, what should we do? How should we feedback our this thing there? What objections do we take? What case laws do we quote, give to our advocate or give ourselves to them? For that, I have prepared some Word files for you, and I'll be sharing these Word files with you on the chat box. And there you can download it right now. Persons who are attending our webinar will have a special privilege of having access to this data, because in YouTube you only are able to hear what we say, what these are. I just stop my PPT here and come back to you, because so that I can share it in the chat box, all these letters. I've shared all these letters in my chat box. If you want, you can download it from there, because it will act as a ready reference for you in your replies to the PF authorities. Or even you can tell if you're appointed an advocate for this purpose, you can guide your advocate also based on these replies. Now let me delve a little bit deep into what these letters, what are the contents of these letters, which is the basic purpose of having a webinar on PF today, because the content of these letters will give you a lot of ammunition to fight for the PF with PF authorities. Just wait for a few moments. I have to come back to my this thing again, PPT. Don't worry, I've shared all these letters with you, and whenever you have a virtual proceedings, this letter indicates that because of virtual proceedings, they have the record of recording. Whatever you say in that particular virtual proceeding, make a letter of it and file it with the concerned authorities, because virtual hearing the virtual hearing attend is given to you on the virtual hearing attendance notice come to you through an email. In that email, you should always reply what you have stated in your virtual hearing. For example, in my case, I said that my adjudication be done based on these letters. At that time, concerned officer agreed for that, and at the same time, I wrote a little bit about the section 14 also. But at the same time, I given the reply to them. What effect I have all these things, I'll let you know later on. First of all, you just have a look on this thing here. You can copy and paste content for as per your requirement later on, but this is my submission to you. Now let me come to you again for my second submissions which I have made.
Excuse me, Manojji, the link you have provided is not opening.
Which link?
You have provided.
I've shared all these letters on my chat box. Are you able to download from the chat box?
No, not able to. Others also have commented so. Can you please start?
I do one thing. Let me complete this thing. I shall share it again, and I shall keep my the meeting open for 5-10 minutes. In that case, you can do it later on. Okay?
Yeah.
Or otherwise, also you can share your email with me. I shall share all this in your email also as a second alternative.
Thank you.
Oh, sorry. Yeah, this I have already shared. Just wait. I'm a little bit getting some problem in sharing of my letters. Yes. As the problem arises with us, you always share with them, because that will definitely help you in your assessments. Maybe before your case before NCLT, or maybe if you file an appeal against their orders. Always plead with them, non-availability of records, defunct business operations as applicable, disposal of, in my case, company has already disposed of the premises approximately a year ago, and you say that they have levied charges against that disposed premises also. Write it clearly that if you want to have a hearing at their place or something like that, you say that currently you're operating from RP's office. You can have physical hearing RP's office. In fact, I must tell you, you have to use your discretion. I have gone to the extent of saying this thing. In the light of the above, I request your good office to share any relevant historical records available with you pertaining to the company in order to assist me in CRP. And I wrote it, give the reference of 19 also, 238 power with me also. I have gone to that extent to asking. What happened is that when you're fighting with somebody, if you show your muscles also, you show your rights also, then you can have upper hand as far as that fight is concerned. Let me move to my another letter. Just hold on. I'm coming out with a relevant letter to you only. Yes. I get furious of their demand. And when I said to them that this demand is not to be kept by you only, this has to be paid back to the employees. Kindly provide me the details of this thing. Give me the employers breakup, bifurcation of the amount, distinguishing principal contribution, interest and penal damages, calculation sources and copies of any inspection or audit report, forming the basis of current demand, clarification on prior adjudication, namely whether any component of the claim has been previously adjudicated on the same line, the line on which you are adjudicating me, specific period of default, contribution rates, and statutory charges, and all this in there. Then I told them these exclusion from liquidation state, as alluded para 2 above, your letter so and so and so. I was running a CRP case. I told them that this provision is applicable only for the liquidation state. This is not applicable during CRP stage. Hence, please, don't bother me with your notices. And I have some case laws on that also, uh, which says that in the case of Sikandar Jain, Sunil, and so and so and so, that it says that 36(4)(a)(3) of the IBC is confined to actual provident fund dues only. That is contribution of the principal employer-employee, and does not extend to penal damages and interest. But here I have my reservation. These are the old case laws, but PF authorities are not much aware of it. You tell them when it is not applicable and you feel these are applicable, come out with your counter replies, or come out with your your view on that. They never come out with their view. They simply sleep over it, and these papers will definitely help you when you fight a case at NCLT or with their appellate authorities. I refer to them that have repeatedly affirmed the proposition, same proposition which I've written above, with these case laws. These, I just, these judgments, you can have, get it copied from me. These judgments collectively and unequally hold that amounts levied by way of damages and interest under section so and so do not constitute amount due to employees, and accordingly don't stand excluded from the liquidation state contemplated under section so and so. The correct legal qualification of such claims is thus an operational debt, see NCLT so and so order. Statutory discretion in case of say companies, I've gone a little bit deep also. The legislative scheme of section 14B of the EPF vests with the center board for discretion in appropriate cases to reduce or waive damages in respect of a sick industrial companies. Kindly clarify whether and not such extent such discretion should not be exercised. What happened in the, although I have not done with BIFER much, but people who are doing the BIFER practice, BIFER board was given a right to waive off all these income tax dues, PF dues, and all this in there. And since our IBC is a replica of BIFER to some extent, whereby our job is to look into rehabilitation of the company or coming out with some plan therein. तो आई से कि जब आप उसके अंदर अपील में रिलीफ देते थे, तो हमारे को भी आईबीसी के अंदर इन चीज़ों से रिलीफ दे दो वॉलंटरली. नो एडजुडिकेशन टिल डेट हैज कम ऑन दिस पॉइंट. बट इफ वो कहते हैं ना, मैं अगर बच्चे 10 बारी कोई चीज़ मांगे तो एक बारी पेरेंट्स दे ही देते हैं. होपफुली मे एनीथिंग फॉल इन द डीप एयर्स ऑफ आर adjudicating authority, our NCLT, and our parental authority, NCLT or NCLT. They may come out with this thing and grant us something like that. Now let me move to my another letter which I have given to them. Yeah, here you'll find something very interesting. what happened when I wrote that particular letter to them and similar other letters to them, they just gave a reply to them after 2 3 months of their analysis and all this in there. But their reply was absolutely bad in law, bad on facts, and I again replied to them in this way. Office premises, still under lock. It happens. The section with non-criminal so and so. 92 already filed, and so I proved my bona fide by saying that I'm not able to give you the record because I've been not cooperated by the directors, which generally happens. I have already filed 92 applications with them for the cooperation, and you wait till the outcome of that per 19 directions from the honorable NCLT, whereby they will ask the employer to give the record to me. But till I get those record, please wait till them there. These letters are there. Another point number 4, incomplete reply by EPFO. Further, the reply dated so and so issued by your office against my earlier email so and so is respectfully submitted to be incomplete and lacking substantive clarification, thereby preventing meaningful response and effective adjudication. I request that a detailed and reasoned response be provided instead of mere superfluous references. What happened? I gave them, as I told you in my earlier replies, that these are the cases which says that 14Q and 7Q liability can't be imposed on me based on. So you come out with your reply against that. Ki, why you want to? Why in my case you should not impose all this thing there? They did not touch this aspect in their reply because they were not having any answer for that, and that gives me ample food. Yeah, if you don't listen to me, your appellant thoughts will definitely listen to me, because I have I shall plead to them that मैंने इनको ये कहा था जी, इन्होंने इस बात को adjudicate नहीं करा, आप इस बात को adjudicate करके ये जो इन्होंने करा है इनको वेव करिए या इनको क्वैश करिए. Yeah, I'm just sharing with you. Just please wait. उन्होंने 2 ऑर्डर से मेरे से ये पैसे डिमांड करे, एंड आई कोटेड देम दैट order so and so is bad in law because these orders are bad in law. Why these are bad in law? I referred them these cases and told them based on these adjudication you can't demand me of based on your content of the order of this amount under section 36 subsection 4 subsection A subsection 3. Again, extended my saying by these 2 law also, and this Tish Kumar case was also very, very important, which says that no the money can be demanded so and so. Another third case is of T Johnson case. Again, it says that it doesn't fall under so and so. NCLT Hyderabad bench also. These my 12 cases clearly establishes the fact that 7Q 14B is not part of 36 for A3 dues. It is under section 53. They have also quoted, 2 cases to me that these cases are in their favor. I rebutted their claim by saying that These cases only affirm that the actual PF dues, principal employer-employee contribution, are excluded from the liquidation state. They don't extend such protection to damages or interests which remain operational claims. We request you to kindly share the specific paragraph or judicial aspect you relied upon if it suggests otherwise. They have no reply for that. Again, what I said to you, that crux of this, my reply is that you are bothering me a lot. You are consuming a lot of my time, which is against yeah, section 14. Now, let me come out with my main letter with you, which is the crux of the whole correspondence with them. There has been two or three, now three judgments are there, which clearly states that after start of the CIP process, when moratorium under section 14 starts, they cannot create any demand. EPF authorities can't create any demand against the CD because after start of moratorium, they are prohibited of carrying any suit against the CD. What those cases are? CA Pankaj versus EPF and others. This is unclear judgment dated 3/25. Another unclear judgment is of EPF for so and so, so and so. Any order passed under section 7A, 14B, 7Q after commencement of the CIP is void, non-est and unenforceable. Initiation or continuation of reassessment proceedings so and so, so and so is unenforceable. You have relied on, they have also come out with two or three judgments, and I analyzed them and said that your judgment does not pertain to creation of liability. These judgments never dealt with demand orders passed after the commencement of CRP. These were delivered prior to 2025 NCLAT judgment, which now have category settled the law. ये जो आपने मेरे को केस रेफरेंस करे थे, उस समय ये केसेस हुए नहीं थे, मीनिंग देयर बाय कि उस समय ये लॉ इन पॉइंट्स पे सेटल नहीं हुआ था. उसके अलावा आपने किसी और पॉइंट पे कह दिया, तो आई एम नॉट कंसर्न विद दैट. पंकज शाह के केस में उन्होंने कहा था कि ये डिटर्मिनेशन ऑफ ड्यूज इज नॉट मेयर सस्पेंड व्हेन इट क्रिएट्स फ्रेश लायबिलिटी ड्यूरिंग मोरेटोरियम. NCLAT, I just shared with you that earlier what our judiciary has taken, that since it is a beneficial law and it should override IBC, all this in there. In these case laws, NCLAT has very categorically held EPF dues are statutory dues, yes, but can't be adjudicated or increased during moratorium. The EPF Act does not override Section 238 of the IBC. If something is coming out from start of the hill, but we have to see water when it reaches to us. What is the quality of the water? Meaning thereby, the latest adjudication has to be shall have an overriding effect of earlier adjudications. When we especially when we want a benefit against that. Yeah, I've disputed their claim on the basis of time also. Within 10 days, we all are aware of it. Within issue of Form A, you have to file it within 10 days. And in my case, request for registration plan was already over. And I said that after 31st July, even you can't file your Form B or F with me. In view of the above, I request for the closing of the proceeding so and so because of the NCLAT binding nature, statutory effect of section 14 to 38, the fact that these proceedings were committed after CRP begun and legal bar against creation of fresh liabilities during moratorium, claim has become time barred. It is respectfully reiterated that the present proceedings are void without jurisdiction and liable to be closed immediately. And what happened, I'll let you know. First of all, let me complete my letters. Let me complete my other, let me share my other things with you. This is the last letter I have given to them. I just share it with you. And there is one more. Legal position, I repeat it again that because of this judgment of NCLAT, your assessment is void and unenforceable. I again reiterated Jayakumar judgment and this thing there. And along with that, I have raised some factual points also. Notice to are required production record within 3 days. It is humanly not possible to give us there. Request for 1 month extension was not given was asked because of the non reasoning there. And your the basis of, in my case, what they did, that they raised the demand based on GST returns filed up to a particular date. Till filing of GST return, they presumed that employees were working there, and hence they created a demand of so and so employees and so this thing there. So I said that your this presumption is bad in law, and based on that you can't create the demand against me. Since I was preparing PPT for that, so I thought of looking into some more latest judgment on that. So I come across these judgments also. These held the same principle what I've just discussed with you, but it can give you a lot of ammunition in your understanding this thing there. I just quickly pass it through because we have already crossed 20 minutes above what we there. NCLAT EPFO can't claim pre-CRP period dues based on assessments after moratorium. NCLAT post CRPF plan proved PF claims unenforceable. That two judgments on it. Rejection of belated PF claims after resolution plan approval. But I have prayed that when I issue RFRP, you can't raise a claim with me. PF dues are not a personal debt. Decision plan can't override PEPF Act. It is contrary judgment. It's only for your reference. Just keep it under your carpet only. Don't show it in cut and paste mistakenly give to the PF authorities. This is PF default is not maintainable Section 9 application. That is, we are not much concerned yet. But this is again Bombay High Court contrary judgment against us. PF not this is again contrary, and take away I've summarized all this thing there. What judicial trend is there, but these are the detail of the what judgments I have shared with you above. These are the details judgment. I'm closing it down. And now, one very Mr. Madan is there. He just shared with me one judgment, very recent judgment. In fact, that is the latest judgment of on EPF dues by NCLAT Chennai. What that is, that I would like to share it with you. ये 17 जनवरी की जजमेंट है, हार्डली 4 days ago or something like that. दिस इज आरपीएफ एनक्लेयर चेन्नई 17 जनवरी 2026 को कहा है ये इट इज अगेंस्ट अस इट सेज दैट पीएफ ओवर ड्यूज विल ओवरराइड योर लिक्विडेशन प्रोसेस एंड ये इन्होंने सेक्शन 36 सब सेक्शन 4 सब सेक्शन ए सब सेक्शन 3 को अपहेल्ड करा है और ये कहा है कि आपको ये ड्यूज जो हैं आपको पहले पे करने हैं तो they have also overridden all the other things सेक्शन 7Q सेक्शन 14B 14B के जो डैमेजेस है ये भी पार्ट ऑफ पीएफ ड्यूज हैं तो liquidator must recognize PF funds and related statutory liabilities outside the standard liquidation state and prioritize their satisfaction in line with section so and so so and so. So this was the all I have with me. Definitely, I'll be sharing it with you. Objective of since we as an RP run process, we need to understand everything in a holistic manner, and then take a call, and then move all this thing there. So this is all from my side. If we have any questions, I open up the box. Definitely, I'm going to share my all these letters with you so that you can also have in-hand information immediately so that we can interact there. If we have Mamta ji aap ho, and if you have any questions either related to Mamta ji or related to me as a PF or something like that, we can डिस्कस इट प्रसाद सर भी हमारे साथ हैं और एजुकेशन करने के टाइम पे इन्होंने भी इस तरह के काफ़ी केसेस देखे होंगे आपका क्या ओपिनियन है तो प्लीज़ कम फॉरवर्ड एंड शेयर योर ओपिनियन बिफोर वी क्लोज डाउन और एज फार एज दिस थिंग इज़ कंसर्नड शेयरिंग ऑफ दीज लेटर्स आर कंसर्न हम इसको क्या कहते हैं I try to put it again in the chat box and just tell me if you can note it down if you can download it now or not.
Manojji,
Yes,
yeah,
sir.
this is Dr. Sriram from Chennai. Very good
Yes,
evening.
sir. Yes,
So
yes,
nice,
please.
so nice having started this kind of the lectures sessions. We all loved it, and Mamta ji also know, and Madan ji, Mamta ji, Anil Goyal, and almost a lot of great people really came and gave a lot of information. I must really thank you all. And I do have a clarification on section 14B of EPF Act. So same amount, almost 1.55 crores, which has been held up, and I'm in a confusion whether I should give back to the EPF department or I should really not distribute it. I'm yet to get any conclusion. The Chennai NCLAT has now given recently on 4 days back a different decision. We are still in confusion now whether I should really distribute or give back to EPF. I'm not yet to really get any information on it. How should I really go about? We are in dark totally.
Sir, in your case, if I've been in your place, I won't say that you do it like that, but if I be in your place, I shall never give the money to them and fight it to at least NCLAT.
But NCLAT has given a clear judgment. Chennai NCLAT has
Sir,
given
this, when Mamta ji was talking about some judgments, so there was Mr. Madan and they were on the, they were on the interjecting each other. And consensus emerged that although their saying is law, but many a times we need to look a little bit deep into it also because we have a lot of ammunition in terms of contrary to that judgment also. But I agree with you. This is the latest judgment. Hardly 4 days are there. 4 days ago are there. Actually, what happened is that many a times judgments do come out, with the predetermined mindset of the judge. What judge? They have a very less time, to think deep into it. They say that this PF Act is beneficiary act, and hence, it should prevail over IBC. That is their thought process. But we as a process, when we are running a process, we try to little bit go deep into it and try to say that we are paying this amount at the cost of our financial capital. We are paying this cost at the cost of our operational capital. That gives me a lot of pain. Secondly, you're talking about the 14Q. Just simply.
No, 14B, yeah.
14B. Okay, 14B.
Yeah.
Just will they give that interest back to the employees?
No, they will not give. That is the
Yes,
confusion.
yes. Sir, on the one hand, you want to make one as
Yeah, it's unjustly they are
the
enriching.
government as a the rich. No, you have to. You have answered yourself. This is your call.
Yeah, thank you, thank you. In any case, we'll decide that. Thank you,
Yes,
sir. Yeah.
No, I told you that if I be in your place, I shall fight it
Understood.
till NCLT. It's a huge amount, and
Yeah,
1.5 crore is a huge amount.
After all, we need to really do justice to all.
Yes, exactly. When we are running a process, we need to look for the benefit of all.
Yeah.
Hanji, anything else?
Thank you, sir.
Anybody would like to come forward and say something? मैंने अभी एक letter, I've just shared one letter. Are you able to download it? Just tell me. In that case, I share other more letters with you.
मनोज जी, ये सभी लेटर्स व्हाट्सएप में शेयर कीजिए ना।
सर व्हाट्सएप में तो नहीं कर सकता ना मैं, ये तो फिर एक थोड़ा सा वो हो जाएगा, समथिंग बैड ऑन माई पार्ट की आई एम गोइंग गेस्ट डिपार्टमेंट. व्हाट्सएप ग्रुप इज़ लाइक social media. Here we have a close knitted group of 50 peoples. What you do one thing. I just do one thing. I just write down my email on the chat box. You please note down my email and send your email therein. I shall definitely give you a reply therein.
Okay, then thank you.
That will be a better option.
Sir,
Because
which is that Madras High Court latest decision? What is the
sir,
citation?
just hold on. Let me, are you able to see my on chat box my email address?
Yes, sir.
Okay, everybody can note it down. I'll be keeping my meeting open for 10 minutes at least, so that everybody can note it down. And then you can send me the email there, and I shall definitely share all these letters with you, because I can share, you understand my limitation also. In public, sharing all this thing, any government department can come after me and say that आप बहुत बड़े नेता बन रहे हो आपस में क्या. But in close knitted group, I can share it with my friends. Yes, sir. Somebody was coming out with something.
So that
there.
Madras High Court citation.
Yes, sir.
Which is that, sir? Recent, that 4 days back.
That is not High Court. It's a Chennai NCLT bench.
Oh,
judgment.
Chennai NCLT. Enclave. No, which
Yes,
was that?
Chennai.
Does it come to your mind? That citation?
Citation, yeah, I've just shown it to you, no? Citation is, you want to note it down right now?
Just say that.
I've given you my email now. I shall share it with you, not only with you, but everybody. But still, if you want to note it down right now, you can note it down. It is given on 17th of January 2026. And this is Regional Provident Fund Commissioner. I just shared it in the chat box.
Thank you.
Just confirm that whether you've been able to look at it or not. I just sharing it on the chat box. Regional Provident Fund Commissioner, second versus Harshvardhan Cotton and Synthetic Mills Private Limited and others, Enclave Chennai, 17 January 2026. Are you able to look into it in the chat box?
Very much, sir. Thank you.
Yeah. Anything else? Okay, with this note, we are closing our meeting. I hope it must have quenched your thirst of understanding latest judgment for the December 25 and PF related also. Let me see if I've completed my PPT or something else is there. Just hold on. If anything else is there, then let me. It won't do justice to you that I missed something with you. But please, just hold on. As far as technical things are concerned, it has almost completed, except 2 or 3 informations which I would like to share with you quickly within 2 minutes only. this is the, a lot of new entrants are there this time because of new membership. This is the we started. We held our first meeting in March 2018 when Mr. Mukhopadhyay, NCLAT chairman, sitting chairman, was our chief guest. And you see behind him is Mr. Nilesh Sharma. He has now been promoted as our judicial member. We represented in all our international events there in Singapore, in there also in 25. I've just shared it with you, and we hold webinars whenever there is any material new amendments come out to be there. These are the list of things. Whenever you feel anything you require, technically understanding anything there, you can have a look on it if you get stuck up with any of your processes. And these are all available with us. For example, on NRRA, we have done a lot of things there where I have given the list of NRA buyers, which is very difficult to do many a times. And financial reporting, how we should go for the financial reporting as far as our when we are running the CRP or liquidation process. This is also there. And similarly, we called from IBBA also in this particular, when IBC amendment bill was put for public appraisal, and we discussed it clause by clause. And as far as PG to CD cases are concerned, we have done a lot on PG cases. That is, you can see, look into these channels also. This is all from our side, APA side. Thank you very much for joining us and encouraging us to be part of the meeting. Yeah, thank you very much. If there is nothing left to be talked, I just close on the meeting. Thank you very much. Thanks a lot. Thank you for joining. We'll be holding next session also very soon as it is required. Yes, please
Manojji,
come
thank you
forward.
very much for this webinar. I request you to share the Google form for admission of our new members so that I can distribute to my friends.
Okay, definitely. You do one thing. When you're writing your email to me for all these letters and this thing, just mention it there to share Google form with you. I shall share Google form along with those letters with you also.
Definitely. Thank you.
Thank you, sir. Thank you very much. Thanks to all my professionals. Thank you very much.